Number 8, Suzanne P. versus Joint Board. Just let the other counsel leave.
Please the court, William Quinlan for plaintiff Suzanne P. I'd like to reserve 3 minutes for a rebuttal, if I may.
You have 3 minutes.
There's liability of 5 defendants at issue, and I would like to start with the joint board and the ownership issue. This court resolved a similar owner issue in the Metro Media case involving the advertisements on the structure of the L stations. And in that case, this court allowed the parties to the agreement to structure their interests in the property.
Counsel, in this case, a jury resolved the ownership issue, not a court.
No, the court did itself by granting a motion for a directed verdict as a matter
After
of
a
law.
jury found that the joint board wasn't the owner in this case, isn't that correct?
Yes.
So are we not really talking here about whether the jury's determination should stand? Because we have competing directed verdicts, as far as I can tell.
No, because there really was no evidence that anybody other than the joint board was the owner under the agreement.
Counselor, isn't the fact that the appellate division and the Supreme Court both directed verdicts for different people, opposing parties here, couldn't that lead us to think that reasonable minds can differ?
I don't
And no one
believe so,
deserves a
given that
directed verdict?
The tenor of this agreement was such that the only person that could be the owner would be the joint board, given the definitions of the agreements themselves. And the fact that there was no issue in this case,
So
that
let me
there
ask you
weren't
this,
permanent
let me ask you this,
easements.
counsel. What has to be owned for your client to be able to pursue this liability? Does it have to be the dams, the land, the creek bed? What has to be owned?
The structures, Your Honor. The structures.
Because they cause the hydraulic boil or whatever it's called?
You believe that the hydraulic boil is caused by the structures. This is like an inherent nature of such a low-head dam is to have that hydraulic boil. And in the agreement, the structures themselves are defined as real property, just as was the case in the Metro Media case. And the issues was raised also regarding, there's no transfer of ownership issue, that once these things were built, they were owned by the joint board, by virtue, again, by virtue of the contract.
Counsel, I have a procedural question. If the court were to agree that neither party is entitled to a directed verdict, my understanding is this correct, that it would go back to the trial court for reinstatement of the jury verdict, right? Is that correct?
Well, I don't know the answer to that off the top of my head, but I just still believe that the only answer in this case is through the agreement and its application, and that there wasn't any other entity put forward besides the joint board as the owner.
So with respect to the evidence that was presented at trial, is it your argument that that which the plaintiff put forth established that that which caused harm was in fact owned by the defendant? It was not rebutted by the other side, so they shouldn't have been granted summary judgment, or I'm sorry, a directed verdict by the appellate division when it then went up.
Yes, because the appellate division set forth a number of preconditions to which really there was no point in going beyond the agreement in this case. Like they imposed a condition that there had to be ownership of the actual creek bed, and they imposed a condition that there had to be transfer of ownership of the structure, when both of those conditions were covered by the agreement. So as was done in the Metro Media case, that this court should allow the parties to the agreement to have structured the ownership of this structure as was their
So do
intent.
you always have to have ownership in order to be potentially liable for a harm caused?
Yes, under the agreement, the joint board owned the structure for the purposes of ownership, purposes of operation and maintenance.
Right, but is ownership always required for potential liability?
Well, no, especially if you're talking about, for instance, the town of West Seneca in this case. Under the circumstances of the Galindo case, this court held that under certain circumstances where the owner has special knowledge of a danger, which the other parties would not have, the public would not have, then the budding owner would have a duty to warn.
But your
And,
theory of liability against the joint board is that they were the owner and therefore liable by virtue of their
Yeah,
ownership.
they were an owner for respect to operation and maintenance, and so I would say that putting a warning would be part of operation and maintenance.
They may have had many duties that they breached,
Yeah.
but it all flows from the fact that they're the owner of the dam. I'm just
Yeah.
going to call it the dam for lack of a better word.
Yes.
Is your position that under the agreements, the joint board is the sole owner, or are there other owners?
I would say that for the purposes, I believe that the NCRS could also be viewed as being an owner of the structure for the purposes of actual repairing and doing major repairs upon the structure. That this agreement divided up the ownership responsibilities regarding this dam.
I want to go back to Judge Troutman's couple questions, because you focused on ownership and the joint board, but there's a whole lot of other people sitting there behind you who don't represent the joint board, and I believe you've sued their clients. Are you saying they are also owners, or do you have different theories of liabilities for each of them? And if I'm jumping too far ahead of where you want to go, just tell me that.
Sorry, regarding the Erie County District and the Wyoming District, refer to them shortly, should be regarded as being a single unit with the joint board. The joint board itself is merely the boards of the Erie District and the Wyoming District meeting jointly. Other than their joint meetings, they have no tangible existence. And if you...
Is that your joint venture argument?
Yeah, the joint venture or partnership, in that when you look at the bill jacket, the way the joint board wasn't referred to it, they referred to them, meaning the joint boards. So they were concerned with how the joint board would further the interest of the respective entities whose
All right,
boards
so
were
let me
making it
just
up.
see if I've got that the right way. It sounds as if you're saying the real entities are the two districts, and the joint board is sort of a doing business as.
Yeah, it's basically a conduit through which monies will be received for the projects of the Erie District and the Wyoming District.
I'm sorry, what's your best case for the proposition that the two districts coming together with representatives on the joint board are a joint venture?
What I'm saying is that they should be regarded as a single unit, that they're really all one. I mean, like, well, for instance, a partnership, like the individual partners are also specific individual legal entities, but it doesn't mean that the fact that the partnership is also a legal entity, that the partners would not be liable for the partnership.
And what would the indicia, do either of those entities exercise some control over the joint board? What's...
Yes, the joint board can do nothing without the boards. In fact, the boards are the joint board.
That's why it's a joint board.
Yes. So really, this is almost kind of a...
So,
like a-
I'm sorry, so if...
It's like a- sorry.
I'm sorry. Let's say the court agrees that the lower court was correct to grant that directed verdict, and the joint board is an owner, and the joint board is liable, then who ends up paying? Erie and Wyoming District board members? who ends up, where's the money coming from?
Well, the way the joint board is structured, there is no insurance, there are no assets.
Right.
So it would have to be the joint, the Erie and Wyoming districts.
So how is it an owner then?
Excuse me, Your Honor?
How is it an owner then?
It's an owner because it is a legal entity that was created by the legislature.
Well, does it have the
And it was-
capacity, does it
it
have
was
the
created-
capacity to sue and be sued?
Yes, it may
Or
be
is it,
sued.
or is it just a doing business name for the two districts?
Well, I would almost say elements of both, really. It was created, well, the reason it was created, because the Buffalo Creek extends into both Erie and Wyoming counties. So in order to have projects for the Erie Creek, you had to create an entity as a conduit for the federal government to have projects on both creeks, in both counties. So the joint board was of the Erie and Wyoming district was created.
It's interesting.
Do you want to address the town of Seneca?
Excuse me, Your
You
Honor?
want to address the liability for the town of Seneca?
Yes, the town of West Seneca, the town cited the Galindo case I mentioned earlier, that Evelyn Hicks was the chairman of the Environmental Commission of the town of West Seneca. She had intimate knowledge about the nature of the hydraulic boil being associated with these dams, and she wanted warnings to be posted, but they were not posted, and she also agreed that the general public is not aware of these dangers associated with the Lowhead
But
dams.
why does the town of West Seneca have a duty?
Because they're an adjacent owner, they own land adjacent to these dams, and they are in the position
Would that be true
of the
would that
landowner in
be-
the Galindo case.
Would that be true of a private owner as well? I mean, if I owned a piece of the land, riparian land there?
Well, that was the situation in the Galindo case, where they said there was potential liability, but under the facts of that case, there wasn't the kind of, like, exclusive knowledge possessed by the landowner, whose housekeeper's husband was killed in the driveway by the falling tree, as there is in this case, where you have just what was absent
So merely
here.
because the structure is in the water, it abuts the land, West Seneca somehow has a duty? They don't control or maintain it.
They don't control or maintain it, but it is accessible from lands owned by the town of West Seneca.
Accessibility creates the duty?
That's part of it, but I think that the duty is the same that would exist in the Galindo case, where
They
there
had
is a
some special knowledge
special
about the
knowledge
risk.
that is not possessed by the public at large.
And is that just because of the location of their land?
Yes,
And
they
that
are
structure?
abutting. This also bears some similarity to the attractive nuisance cases like Leon versus City of Utica, Skirty versus City of New York, the Gaydon versus City of Rochester, where basically you have abutting, there's ways of accessing areas that are attractive to children through, holes in fences or pathways which are known about, and it's held that there was a duty in those cases as well.
And the county, do you want to address the county at all?
Well, the county is in this two ways. First, if it wasn't for the county, there probably would have been warnings up, and probably this accident would never have happened. But the county told Mr. Gaston from the joint board or from the Erie district, don't put up warnings. It would be
When you
it would
say
be
the county,
the county
as in-
attorney, Erie County attorney.
And isn't that different, having your legal advisor versus the entity itself do something?
What I'm saying is that this is analogous to the Davis case. involving, there was the case where there was medical malpractice committed by a hospital with respect to allowing a patient to drive on medication, and then the hospital was held liable to a person who was injured by the
But
patient.
legal advice is different. The giving of legal advice, you're saying the faulty legal advice is the reason for liability here?
Well, to the extent that there were no warnings posted, yes. And I think really there should be, as a matter of public policy, warnings should be encouraged. And that if in a case such as this, if a municipal entity tells another quasi-municipal entity, don't put up warnings, you'll
And it
be
doesn't matter
liable.
that that was done through their legal advisor?
Yes.
Can you think of a case where a lawyer gave advice to a client, and had the lawyer given different advice, some third party would not have been injured, and a duty in negligence was extended to the lawyer?
Well, I cited cases that are analogous to that in the original brief. You know, it was kind of the assumption of a duty. If they assume to give advice on this subject, they have to give careful advice, especially when it's advice concerning an area that's a known dangerous instrumentality where four people had already died at that area, including a West Seneca firefighter who was killed saving others there. And they also had involved themselves through a public benefit contract with the Erie District, in which they basically assumed the duty of an owner when they contracted to have the Erie District maintain these low-head dams. If they didn't have authority of an owner, in other words, they were assuming the authority of an owner when they made such a contract with the Erie District to maintain the low-head dams. So in other words, under the totality of the circumstances, I think the county bears responsibility for there being a failure to warn regarding the dangers of these dams.
Thank you. We have a large group. My first listed is Erie County. Mr. Toth?
Jeremy Toth for Erie County proper. Just to pick up the conversation. So under the Soil and Water Conservation Law of New York State, the directors may call upon the county attorney for such legal services and the district, as the district may require, and the county attorney shall render such service. This is not a voluntary assumption. This is not something that we can decide not to do. This is not stepping outside of our authority. We are required, when called upon, to provide the best legal advice that we can.
So let me ask you about a different part of the Soil and Water Conservation District Law, which defines a district, and it's Section 3. It says, "District or Soil and Water Conservation District means a county whose Board of Supervisors has by resolution declared said county to be a Soil and Water Conservation District." Why do you think, if you do, that the Soil and Water Conservation District and the county have its separate legal existences?
I mean, it would go back to the creation of the Soil and Water Conservation Districts themselves, and my understanding, this is pushing sort of my historical knowledge, but my understanding was that it was based on funding mechanisms created by the federal government post-World War II as the expansion beyond urban centers was growing. The concerns about the watersheds, for in this case Lake Erie, became a real concern. And so in response...
That explains why the money got there, why there was a need for money to go to certain things, but why do you read the statute as creating a separate legal entity out of these districts rather than what it appears to say on its face, which is the county is the district, if it so chooses?
I understand the question, and I think pretty clearly the legislature created what I consider a separate and distinct entity, can sue or be sued, has its own directors that act independently from the county that sponsored them. The closest analogy that I can come up with, and this is fairly esoteric stuff, I think, but the community college system is very similar, where a county sponsors the creation of a community college, but then that community college is ultimately an independent entity with its own power, its own authority, and similarly, my office and other county attorneys will provide legal services to that community college, but it is a separate and distinct entity. It's a sort of an idiosyncratic nature of the law that doesn't apply often, but I think pretty clearly from the plain reading of the statute, you have to consider a soil and water conservation district as an independent entity. I don't think you could read that statute and conclude that it is in fact Erie County. It is a separate
Can I
entity.
just ask you, with respect to the pleadings and the plaintiff's theories of liability against the county, was this sort of, what I think Judge Wilson might be getting to, is this sort of vicarious liability for the district pled, or was the only theory of liability against the county that was pleaded the bad legal advice?
So the two theories that I recognize from the pleadings over the past 10 years is the advice from the county attorney's office, and then this concept, and again, it gets to the ownership, and that's essentially what we have. We have this premises liability case where nobody actually owns the premises. That's a very idiosyncratic nature of this case.
Somebody has to own this premises, right? That's the vexing part of this case, and I realize that two courts found in completely opposite ways regarding the ownership, and a jury basically signaled that the burden of proof as to ownership hadn't been met, but somebody has to own this.
I mean, if you look at the actual surveys, and I quite frankly don't know if the surveys are in the record, I believe there are some, it's private landlord owners. The lines go to the center of
The landowners from whom easements were taken?
Yes.
So their property became subject to an easement, and yet they own the dam that's on it?
Again, it's an idiosyncratic and difficult question to resolve.
It's
I
a
think-
little hard to square with the fact that the government that designs it, funds it, builds it, doesn't think the landowners own it.
And you're referring to the federal government in
Correct.
that case, yes. I
Correct.
mean, part of the sort of question mark over this litigation is, where is the federal government in this? And
Well,
why,
they're in an agreement.
why aren't they there?
They're in an agreement that says the joint board is the owner. That's where they are.
But that agreement, the use of the word owner, does that convey the sense of sort of a fee simple? And I feel like I'm going back
But
to
is that
property law.
necessary for this purpose?
I believe that it is. I believe that it is. If for no other reason, then none of the defendants at this table have.
By the way, it can't be a fee simple because it's not real property.
I'm sorry?
It's not real property, so it's not a fee simple. It's not an estate in that way.
You're referring to the dam.
The dam.
But if the dam is a fixture,
It's part of the land.
it's part of the land.
See a fixture when, again, the builder, designer, the person who paid, or the entity that paid for it doesn't view it that way, didn't negotiate it that way.
How about I stand, the
Anyway.
county's not the owner. How about
Anyway,
that?
that's fair
My
enough.
client is not the owner.
All right.
Fair enough.
Thank you, Mr. Toth.
Can I
Okay,
just have
thank you.
one
Go ahead.
one
I'm
question?
sorry,
Were
one more
any
question.
easements put into evidence?
The record is so big. I don't believe so, but co-counsel would be better.
I'll ask again, yes, thank you.
Thank you.
Our next respondent is Town of West Seneca.
Good afternoon. May it please the court, I'm Norm Green. I represent the town of West Seneca. In addition to the use of the cane, I have a little bit of a hearing problem, so speak up. And if I'm inordinately loud, I apologize. The first thing I want to mention is that the plaintiff's attorney mentioned the Galindo case. I hope you folks are familiar with the facts in the case because Galindo supports the position of the county here. The tree was on the town of Clarkson land. The tree was on town land, and Clark was the adjacent landowner who, the court determined, this court, had no responsibility even though he was an adjacent landowner because, and I could quote the case for you, but I see that you're obviously familiar with it. As a general matter, Court of Appeals speaking, an owner has no duty to warn or protect others under the circumstances portrayed there, even though Clark, the adjacent landowner, saw the tree was leaning and recognized that it posed a danger. Now, the question arises here, as far as I can see, these youngsters, this is a tragedy. There's no question about that. That's not an issue. But the fact of the matter is that these youngsters, full of life, entered the area where the dam was from private property. They didn't cross any town property. And even if they would, there wouldn't have been necessarily liability under a couple of cases that I'm going to refer to you and which were in our brief. In other words, the situation here is these youngsters crossed private property, and as Mr. Toth suggested, the private property on deeds and things extends to the middle of this creek. Now, you well know that most navigable waterways in the state of New York are deemed owned by the state. In other words, we go out here on the Hudson River. It isn't that the city of Albany owns the Hudson River, but this is a different situation here. These low-head dams, the sills, had nothing to do with the town of West Seneca. The fact is that West Seneca land was not adjacent. There's a couple of cases that are cited. Lewis against the town of, city of Utica, a case where there's a hole in fences. But that's directly adjacent to municipal use. Municipality has a park or something like that. And as a matter of fact, because of that, holes in the fence permit access and liability can arise and probably should if there's an irresponsibility with regard to that. But the situation isn't present here. The town has a couple of tracts of land, but they're not recreational area. If you look at page 387 of the Evelyn Hicks's testimony, you will see that the areas adjacent to the creek in the town were not recreational areas. And so the main point that I want to raise is to invite your attention to a couple of cases. I think they're important and they're interesting. One of them is Garner v. the City of New York. There, the City of New York owned a beach, and there was a private beach right next to it. And some very serious injuries were sustained by swimmers. 4 youngsters in water directly adjacent to the beach as a result of a steep drop-off and unusually strong and hazardous currents were, as I say, very, very seriously injured, 4 of them. And yet, there's a city beach right next door. And as a matter of fact, one of the issues in the case that the plaintiffs raised there was that there was a bulkhead on the adjacent city property that might arguably, based on a couple of expert affidavits that were proffered in the course of the litigation, that might conceivably have caused these currents. That case, a fortiori, is much stronger for the potential imposition of liability because, A, the city did own the adjacent property directly next to where the youngsters were hurt, and B, there was conceivably, in addition to ownership, the presence of a bulkhead. I see that my argument time has expired. I take it very often silence is golden. That's not always the case. That's not always the case. Justice Troutman would know. And I will answer any questions that any member of this inestimable court cares to pose for me. Otherwise, I'll take a seat.
Thank you, Mr. Green.
Thanks very much.
The next respondent is the joint board.
Good afternoon, Your Honors. Mark De La Posa on behalf of the Joint Board. I've been with this case since the very beginning. I think I'm the only one that's been with this case since the very beginning. And I tried the case in front of Judge Grisani, and we're here today.
Counsel, before you start on the other arguments, do you know the answer to my question? If we were to decide that a directed verdict is not appropriate for either party, what would happen?
I believe it would go back to the court, and they would reinstate the jury's verdict, which was made after listening to the evidence.
And then that could be appealed under the standard for review of a jury verdict, right?
I guess it could, but I think whatever's going to happen as a result of this will probably take care of that, no matter which way you decide, I would think. But
Thank you.
sure. So in order
So counsel,
to...
if the joint board is not the owner, who's the owner?
Well,
Or owners, if you think there's
Or
more than
owners.
one. Yeah.
under riparian law, it's the owner of the creek bed, which is the state of New York, if it's a navigable waterway, or it would be the adjoining landowners if it's an unnavigable waterway. This was probably a navigable waterway. The state of New York has been sued in the Court of Claims. That claim still exists against the state of New York. I don't know what is going on over there, but my guess is they're waiting the determination in this case, as often happens in the Court of Claims, before they make a decision.
What is the joint board? Does it have, is it a legal entity that has the capacity to sue and be sued?
It is a legal entity that has the capacity to be sued and be sued.
And how do we know that?
I believe that's what the legislator created in making the joint board, which is not the entire boards of both the Erie and Wyoming, but members of the boards, and they become the board for the joint board. They meet occasionally, and they oversee the joint board's activities, which the joint board has no employees, they have no land, they have no offices. They're basically made up of Erie or Wyoming County individuals that do the work, which in this case, their only work is the operation and maintenance.
And there's nothing in
of
its
this- of these
statute
sills.
expressly giving it the power to sue or be sued. Is that right?
Correct,
Okay, so it would have to be implied.
yes.
Okay.
But it is a separate entity from the Erie and Wyoming, and I think it's treated as such in what I've seen.
Is it a separate entity created out of the collaboration, the joint venture of two,
No.
Districts?
I believe it would be, what was said previously was that it was created as a funding and oversight mechanism for the Flood Control Act that happened after the Second World War to improve the watersheds in waterways such as the Buffalo River and Lake
it
Erie.
is true that all the work that was done under the aegis of the joint board was done by an employee of one or the other districts. Is that the case?
It has to be correct because there are no employees of the joint board. So I don't know who would do it otherwise.
Are
But-
all the board members of the Erie and Wyoming districts members of the joint board?
I don't believe all of them are, Your Honor. I believe certain of them are.
So, I'm sorry, then, how do you end up on the joint board?
How do you what?
How do they end up on the joint board? If it's not all of them?
I think I don't know the answer, Your
Okay.
Honor. I apologize. But in order to qualify someone as an owner, You either look at common law, which we've done in terms of riparian rights, or you look at deeds or easements. In this case, there's no easements in the record. The easements, the only ones there are, just give permission to the joint board to go over their property to do the inspections they need to do on these sills.
And the agreements here, what do they do?
The agreement, if you look at it, Your Honor, and I think the reason why it wasn't or should not have been decided in favor of the plaintiff as a directed verdict was because there's confusion or it's not clear in terms of what it is. If you look at the agreement, which I think is 9 pages, the first 4 or 5, first 3 are specific to this project. The other 5 look like boilerplate type language. And if you look at the definitions, and if you're going to say there's no other way to read it other than that, which is what Judge Grisani did, real property means land, including land improvement structures and appurtenances. So they're treating them as a single entity, not here's the dam, it's a structure, here's the property, it's a structure. They're treating them as a single entity together. And if you look further down, it says title to all real property shall vest in the sponsor. Title is a legal term, and you got to have a deed. You can't just say, I'm the owner,
So
and you
the
can't have two
parties
people.
can't contract a different definition and make the sponsor responsible?
I think they could, but I don't think they get there on this agreement. The word owner is never used in this agreement. They call it sponsor. They talk about title. They talk about real property and appurtenances and structures. So if you're going to make a decision that holds my client responsible, abrogating common law and everything else, it has to be clearly stated, and it isn't clearly stated.
So your client can be responsible for overseeing the structure,
Operation and maintenance, yes.
but if something happens based upon their directing how that's to be done, they're not responsible for anything because they don't own it.
Well, if you look at the actual testimony, the joint board has very little ability to do anything other than make annual inspections. They have to get permission from the federal government to do anything. You can't redesign it. You can't add stuff on. It's very unlike the Metro Media case, where they really didn't have the chance here to control, or they
Well, is
couldn't
that
even
in-
put up signs if they
Well,
wanted.
that may go to the merits of liability, but the question is whether or not, right, they can even be sued for it, no?
I guess I disagree. I don't think they can be sued. They have been sued, obviously. But I don't think that they're responsible under this agreement between the joint board and the federal
So
government.
you're
Federal government
saying
was
the
never,
agreement does nothing?
I'm sorry?
The agreement isn't sufficient to do what the plaintiff thinks it did?
Correct. It does something. It gives them the opportunity to operate and maintain it, and the government oversees that as well. The federal government oversees that as
Did I
well.
misunderstand you? I thought you said that the agreement said all these things are real property, and then title is in the sponsor. Did I misunderstand you? That that's what the agreement says?
The agreement says real property means land, including improvements, structures, and appurtenances. So they're treating them as a single
Yes,
entity.
and
Last title.
and didn't you say that the sponsor holds title
It says
to
titles.
that property?
Yes, but.
Yes, that does, don't we understand that in the law to mean that one has an ownership or some kind of property-based legal interest that may then subject
If the
you to
federal-
liability? May, I didn't say it should in this case, just may.
If the federal government had title to vest, had title to transfer, I would agree with you. This seems to be triggered to a situation.
Why wouldn't it have, didn't it design it, build it, fund it? What did I miss?
Because they didn't have title to the property, and title to the property and the structure go together, and they have to be able to transfer it over.
That's not the intent of the parties, to have that kind of ownership. I'm not really clear how it rises to what you're saying. The agreements are clear, that
But-
there's no intent for anyone other than the sponsor to have.
But if the agreement says
You know?
you joint board can't do anything essentially other than inspect it once a year, how are you, that seems to go against common law in terms of the perception of what owners' responsibilities are. If I can't go in there and improve this thing and put up signs and put up warning signs, now I'm going to be held liable. It should be the federal government or the state, but really the federal government, who for some reason didn't get sued here.
Thank you, Mr. Delaposta.
Thank you very much, Your Honor.
Next is Erie County Soil and Water.
Good afternoon, Your Honors. Justin Hendricks on behalf of the Erie County Soil and Water Conservation District. Just wanted to start by saying that, Justice Wilson, I think you nailed the central question on the head in that is the joint board more than a simple DBA of the underlying Erie County and Wyoming County Soil and Water Conservation Districts? I think it sort of has to be for no other reason than it is here and has been sued. It has counsel.
Well, I mean, we
Give
have
a trial verdict.
cases about capacity where we hold that somebody who's been sued can't be sued. I mean, our District 37 case, for example, is a good example of that. So the fact that they're here doesn't mean that they should or can be here.
True, but beyond that, you know, the legislature specifically created it for the purpose of administering this watershed, and it needed to be so empowered to accomplish those ends.
Well, that's a question of whether it needs to be empowered to sue and be sued, or whether it really has no separate legal existence, even though it's sort of an unincorporated association or a DBA or something like that. But,
Okay.
I mean, continue if you like, but I...
Okay. And then just the second point to touch on, that the joint board can't be considered a joint venture as plaintiff is putting forward, first and foremost, because the legislator did specifically create it. You know, this wasn't similar to the cases that are cited by the plaintiff where...
Well, you're not saying the legislature couldn't create a joint venture, I assume.
Well,
Maybe you're saying they didn't, but the fact that the legislature created it, it could have created a joint venture, right?
The legislator is certainly empowered to create a joint venture.
Okay, yeah.
But, you know, in this case, you know, they did not, again, because when you read the generating document, it speaks for itself. If there are any questions, otherwise, co-counsel has certainly addressed most of the issues at hand. So, thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Brianna Riley on behalf of the Wyoming County Soil and Water Conservation District. I will refer to as Wyoming District. A lot has been discussed so far. I'm going to be direct in this case was decided twice. The Supreme Court, the Fourth Department, I ask that you uphold their decisions for this purpose. Wyoming District, first of all, this incident, this tragic incident, this happened in Erie County. The structure is in Erie County. I understand Wyoming County waters, you know, flow through. Ultimately, this Wyoming County District is separate from this joint board. This joint board was created because there was a project needed, this Buffalo Water Creek project. They needed someone to, they needed an entity, not someone, an entity.
Is that the opposite of what we just heard? Did I just hear from the last attorney that the joint board is a DBA for the districts?
You know, I'm not, I can't speak for him,
Okay.
but just to be.
Do you adopt that position?
No, I would say that the joint board is a separate and distinct entity. I would say that it is an entity that clearly can enter into agreements, contracts, as it did with the federal government, an entity that, I know that question, can sue or be sued. I'm of the opinion, and I believe that the surrounding circumstances support the position that they can.
And it can be liable, and then how would it pay for any injuries, damages that it has to pay for?
Well, respectfully, whether they choose to get some type of insurance, whether they choose to, that's
Well,
something.
they have none, correct?
To my knowledge, I don't want to speak for them, but
Okay.
Did the joint board make any requests for indemnification in their pleadings?
Your Honor, I'm not quite sure, but to my knowledge, I don't believe so. Ultimately, I will take any questions from the panel, but
Do you know how people get on the joint board? Do you agree that not every board member from the county soil districts is on the board? Yes?
I do agree with that. And to address your question, I believe
Yeah.
that they could be appointed. I believe that would be by the members of independent boards can maybe appoint members to create this joint board. But that's just not, it's not something I can quote from, but that's just my understanding generally.
Are there bylaws or anything like that that would shed light on that?
Are there, I'm sorry,
Bylaws?
of the joint board?
Yeah.
To my
Or
knowledge,
or of the Wyoming district, let's say, that would specify how members are appointed to anything like, any document you've ever seen?
not to my knowledge. I don't represent the joint board respectfully, so I don't know the particulars of their nature.
Thank you.
Thank you, Your Honors.
First, regarding the town of West Seneca, I'd just like to reiterate that there is a portion of the Galindo case that does specifically reference this type of situation where there's some dangers from knowing neighboring property which might be so clearly known to the landowner, though not open and obvious to others, that a duty to warn would arise. And I would say that this is just such a case. Regarding the issue of the easements, the easements were not admitted into evidence, and the reason is because Mr. Gaston admitted to their existence in the trial at page 2032 of the record. And I would just say these easements were not limited just to inspection. Those easements were a condition precedent to these things ever
Record
being
is-
built.
I'm sorry, counsel, is the scope of the easement, is that information in the record in this admission?
Well, the scope of the easements is provided in the contracts, that they are necessary for the construction. That is.
And those are in the record?
Yeah, that's in the record. That's the original 1959 contracts provide that these easements had to be obtained in order for there to be construction of these low-head dams.
So your position is the scope of the easements is what's represented in those contracts?
Yes. And yes, and it is true that there's other easements that were and are in existence for inspection, but easements specifically, permanent easements specifically had to be obtained in order for these things to be constructed and reconstructed. And I would just also say regarding some of the statements by counsel for the town that they're getting into issues of causation where really this appeal is about really whether there's a duty. So I think some of the arguments are really kind of getting ahead of the issues here. And that's all I have here.
Thank you very much. Thank you, counsel.